Hello, Business Law 1. Welcome to Unit 2, Section 1 on consideration. So now we're going to go into an in-depth analysis of the term consideration. First, I'd like to begin with Scripture, Romans 3:23. For all have sinned and fall short of the glory of God. We all have. But the good news is we have a Savior who understands this and seeks us out regardless. All right, need to move on. The next page in the outline, which is what I'm walking through, is called Quiz, Chapter 12, Consideration. This is your own self-quiz. Go ahead and use these as sample questions and then look up the possible answers. Just to kind of give you a flavor for the kind of questions that you might see on the exam. Consideration, that's a new word for some folks. It has a long drawn out definition which we're going to break down and give you examples so that you can fully understand it. So let's go ahead and begin that. Consideration must be given in order to make a contract legally binding, legally sufficient and bargained for value given by the promisor in return for the promisee performing or refraining from performing an act. So consideration could be doing something, and consideration could be not doing something of value that you otherwise had a right to do. What I'd like to focus in on is the bargain for exchange aspect for the definition of consideration. The big deal here is that the bargain for exchange induces the promise. So what one party provides as consideration is inducement on the other party to bind themselves so that together as they trade consideration with one another, they understand that they're binding themselves to fulfill that contract. All right. Sometimes the best way to understand consideration is to understand what it's not. All right. Insufficient consideration is what I'm looking at here now. They fall into a number of categories. Pre-existing legal duty. When somebody already has a legal duty to perform, then if they promise to perform the same thing, well, that's not consideration. They've already promised to perform it. And so that would be considered insufficient consideration. So, say, for example, if you advertise for you to pay $100 to somebody who will save your cat that's stuck in your tree, and the fireman and the fire truck comes by and sends up a ladder and saves the cat and brings it down to you, they're not entitled to that $100 because they already have a pre-existing legal duty to perform those kind of acts. All right, so it's insufficient. A better example for business purposes would be, for example, let's say you have you want to build a house, and you have a contract for this company to dig the hole for the foundation. All right, and they sign a contract for $10,000 to do this. And halfway through, they run into some obstacles, and they stop and they say, well, it's going to take another $10,000 for this company to finish this job. Well, and you agree to it because you're on a tight schedule. Well, is that an enforceable adjustment to the contract since they already had a pre-existing legal duty to perform? And the answer is the change is not enforceable if they have an already legal obligation, duty to perform. All right, and we'll get into that example, and we'll tweak that example as we go along. The next category of insufficient consideration is past consideration. Very similar. If you've already agreed to perform, then a re-promise to perform again does not bind the other party to any new conditions if the party is not trading consideration back and forth. All right. Illusory promises. Illusory promises are promises that don't really bind the party. Like, for example, I promise to dig that hole for your foundation if it works into my schedule, if I feel like it. Very vague language. You're not normally going to see that. It could be verbal. It doesn't really bind the party. It has to be language that's specific enough and volitionally enough to bind the party. And what I mean by that is it has to specifically obligate the party to perform, not with all these conditions that are based on how a person feels or if it might work, that kind of thing. All right, you have a couple of cases that I'd like you to review in class, or to review and submit to help clarify that. Let's go back to the construction example. What if the contractor runs into something that's unforeseen, like bedrock? Well, within each industry, there are standards of care, standards of performance that have to be observed, and normally the contractor would do soil testing, soil borings into the ground to see if there's any obstruction before they created a bid. That's their responsibility. If, however, they do their due diligence and they do the soil boring to see what is in that hole that they're supposed to dig, and they do not discover any bedrock, then they have a right to stop where they're at and be able to amend the contract or get out of the contract. All right, if something like that were to occur, that's where we get to the term rescission and novation. All right, item 4 in your outline, settlement of claims. This is the unmaking of an existing contract and making a new contract between the same parties. And this is to account for any unforeseen difficulties. So, for example, back to the contractor digging a hole for the foundation for my new home. All right, as I've already stated, they can't stop for no reason and then say, I'm not going any further unless you agree to pay me more, because that's a pre-existing contract. However, if they practice their due diligence, they tested the soil, and unbeknownst to them, after reasonable care, they run into bedrock, they have a right to stop and ask for additional compensation to complete this, because they did not agree to dig something that had this big bedrock in the middle of it. And so that would be called, if they stop, they want to rescind the contract. If we form a new contract, if we agree to a new contract where I agree to pay them more, that's called novation, rescission and novation. Vocabulary terms. Another set of terms I'd like you to understand is called accord and satisfaction. Let me read the definition from the outline. An agreement between the obligor, the debtor, and the obligee, the creditor, by which the obligor agrees to pay the obligee some amount owed under the contract, generally less than the amount in dispute, in exchange for discharge of the obligation owed by the obligor to the obligee. Now, this is best understood through this example. At one time, I went to the dentist to have a dental procedure done to my teeth, and thought that the insurance was going to cover it. Well, after the procedure was done, later found out the insurance didn't cover it, and it was like a $2,000 bill. Well, I was kind of upset, as you might understand. But it wasn't really the dentist's fault, although I would have preferred them tell me up front whether the procedure was covered by insurance or not, but they didn't. So I did owe the money. So I didn't have all the money up front, so I paid them by installments. I paid, let's just say, $100 every month, and it was going to be paid at the end of 24 months. Well, the dentist decided to charge me interest for the unpaid amount every month. So every month I would pay $100, and let's just say the bill was $2,400, and now it's, in my mind, now it's $2,300. Well, he would add like another $20 worth of interest charges. Well, I didn't agree to pay any interest on the balance. I did agree to pay the bill, but I didn't sign any documents that said I would pay any interest on the unpaid balance. So there was a reasonable dispute. All right. So an accord and satisfaction is where the two parties agree to pay a certain amount and agree that that would be the full payment. Well, that works but we have to understand that there's two different situations that that speak into this. If it is a liquidated, and this is in your outline, liquidated or undisputed debt, the debt whose amount has been ascertained or fixed, agreed on, all right, that's one situation. The other situation is where it's unliquidated, where the debt whose amount is in dispute by reasonable persons. Okay? Now, in accord and satisfaction, let's read it. To occur, the amount of the obligor's debt to the obligee must be in dispute, must be unliquidated. That means if there's a reasonable basis for the dispute and the dentist signs the accord and satisfaction, then they are agreeing to accept the amount that might be less than what they first established or first determined. However, if from a reasonable person standpoint the amount is fixed, it's undisputed, okay? Even if the dentist signs it and collects some of the debt from the patient, they could still go back and try to get the remaining amount, even though they signed an accord and satisfaction. All right. So in order for an accord and satisfaction to be effective, the debt amount has to have a reasonable basis to be disputable. Okay? Hope that helps. The last topic, second last topic that we're going to cover is called releases and covenants not to sue. All right, a release is an agreement whereby one of the parties forfeits the right to pursue a legal claim against another party. Well, releases are generally effective so long as they're done in good faith, they're in writing, and they're accompanied by consideration. Once again, there has to be a trade. So, for example, let's say I hereby agree to pay you $500 to release my company from further requirements on this job site for the contract. Let's say you hired me to do some work on your site. All right. A release is, this example again, I'm going to pay you $500 to release me from any further requirements on the job site so I can be finished, and that you won't continue to say I'm supposed to do this or I'm supposed to do this, so long as I act in good faith. And now what am I exchanging? I'm giving you $500, and you're signing off that you're done and won't hold me obligated to any further work at the site. All right. This is different than a covenant not to sue. Okay. A covenant not to sue, let me read it to you, is an agreement to substitute a contractual obligation for some other type of legal action based on a valid claim. So, for example, I hereby agree not to sue for any of the damages that might be result from performing this construction. All right. So I've performed some construction, and there calls for me to do some more construction on the site. I'm having you sign this covenant not to sue, that in case I do this other construction, you agree not to sue if the construction is not done, so long as I act in good faith, does not cause any other claims. Otherwise, I don't want to do any additional construction on your site. All right, so this is a covenant not to sue. Other examples are, let's say you have an accident and you accidentally bump into another car. You can pay the other person, and they can either sign a release or they can sign a covenant not to sue in the future based upon the consideration that you paid at the time of the accident. Finally, last concept, promissory estoppel. Now that's Latin, and it basically translates that I am stopped from claiming that there was no promise. Okay? I am stopped from claiming that there was no promise. Now you can read through some of the elements for that. The promise must be clear and definite. The promisee justifiably relied on the promise. The promisee's reliance was substantial and definite. And 4, enforcing the promise will serve the best interest of justice. I want to go back to an example that I used in a prior lecture where, let's say I'm renting a building, renting an old farmhouse, and the landlord and I agree that if I pay 3 times the amount of the rent for the next 5 years, that I'll own the farmhouse, that the landlord will deed over the property to me, okay? And I go ahead and start making improvements to the property, big improvements. Let's say I pump $150,000 worth of improvements into the old farmhouse, new roof, new foundation, new windows, etc. All right? And now we get to the end of the 5 years, and the landlord says, I don't know what you're talking about. That was never put in writing, and you should take business law 1 because you know that contracts involving real estate must be in writing. All right. Well, this concept could come into play. In fact, this is the vocabulary that an attorney would use and claim that the landlord is stopped from claiming there was no promise based upon all these surrounding facts. The facts that I paid 3 times the amount of rent, the facts that I made all these improvements into the property that the landlord knew about. Those are all going to be contributing factors to establish a quasi-contract where the court is going to say you are stopped from claiming there were no promises because of all these facts that indicate there was a promise. All right. All right, that concludes the details for consideration. And once again, once we're in class, or if you have any questions, please email me. Thank you.